Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in for the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On May 16th, the court decided Federal Election Commission versus Ted Cruz. Listeners may remember our guest today, Professor Bradley A. Smith of Capital University Law School, who joined earlier in the term for the post-argument segment. Today, Professor Smith, former chairman of the Federal Election Commission, joins to provide expert analysis on this decision.
On May 16th, the Supreme Court decided Federal Election Commission versus Cruz. This is the first campaign finance case in which the court has issued a full set of opinions on the merits since McCutcheon versus Federal Election Commission back in 2014, so it's an important marker of where the court stands, and in particular where the three new justices, Gorsuch, Kavanaugh, and Barrett, who have joined the court in the last 5 years, stand on the issue. Cruz, as I refer to the case, deals with the relatively obscure amendment to the Federal Election Campaign Act that was added back in 2002 as part of the Bipartisan Campaign Reform Act, BICRA, as it's sometimes called for its initials, or as it's often known, McCain-Feingold. The case came up through the court's appellate docket, so the court did not have the option of simply denying certiorari. It had to do something with the case. But the fact that the court did not just summarily affirm the lower court and instead set the case for argument and eventually issued full opinions indicates the importance the court put on the constitutional issues in the case. When Congress first placed limits on contributions to campaigns as part of the Federal Election Campaign Act amendments of 1974, it had the obvious and intended effect of making it harder for candidates to raise money, and in particular, it made it hard for campaigns to raise money quickly, since any one donor was limited in the size of his contribution. And in those days, one couldn't just turn to small donors on the internet. It was a time-consuming task of individual and direct mail solicitations. One way a campaign could raise money fast, however, in those old days, was if a candidate could fund a substantial portion of his own campaign. Given the many advantages incumbents have in raising small dollar donations, self-funding was particularly valuable for challengers, and over time incumbents grew to fear self-funded candidates precisely for the ability of such candidates to compete financially. BICRA included a couple of provisions aimed at curtailing these self-funded candidates. One was the so-called Millionaires Amendment, which allowed candidates facing a self-funder to solicit and receive contributions in excess of the usual limit. This was held to be unconstitutional by the Supreme Court in Davis versus FEC in 2008. Another was the provision at issue here in this case in Cruz. The provision limits a candidate to repaying no more than $250,000 of a loan from the candidate with funds raised before the election unless the repayment occurs within 20 days after the election, or with funds raised after the election at any time. Oddly enough, though the legislative history clearly indicates that the provision was expected to harm challengers more than incumbents, it was an incumbent, Senator Ted Cruz, who launched this particular challenge to the provision. You may recall that in 2018, not a very good year for Republicans generally, Cruz was heavily outspent in his re-election campaign by Congressman Beto O'Rourke, basically by a 2-to-1 margin and tens of millions of dollars. Shortly before Election Day, with polls tightening, Cruz loaned his campaign $260,000, and after the election sought repayment from the campaign using funds raised after Election Day, and thus he had to challenge the bar on repayment of more than $250,000 from funds raised after Election Day. Now, it should be noted that it is quite common for campaigns to go into debt and for that debt to be paid off after Election Day, with funds raised after Election Day. Raising such funds can be difficult, especially for defeated candidates, but it is done routinely, and these funds are subject to the same contribution limits as all other funds raised by the campaign. No direct corporate or union contributions, no foreign contributions, and individual contributors limited to $2,900. This $2,900 individual limit is an aggregate limit for the campaign. So if the potential donor had contributed $1,500 before Election Day, he could only contribute another $1,400 after Election Day to retire debt. A donor who contributed a legal maximum of $2,900 before Election Day cannot contribute anything to the candidate's efforts to retire the debt from that campaign. Senator Cruz's argument was quite straightforward. If it's not corrupting for a contributor to give $2,900 to a campaign before Election Day, it's not corrupting to give $2,900 after Election Day. And if it's not corrupting for a candidate to use money raised after Election Day to pay off the first $250,000 owed to the candidate, then it's not corrupting to pay off the next $10,000 with money raised after Election Day either. The government's primary argument, and that of Justice Kagan, writing in dissent for herself and Justices Breyer and Sotomayor, was that there is a particular danger of corruption when contributions raised after the election are used to repay a candidate loan. According to the dissent, these donations are particularly corrupting because the speech they fund has already occurred, and thus repaying the candidate does not produce more speech. And further, the repayments directly line the candidate's pocket, since it leaves the candidate with more money than he would have, basically if the campaign simply defaulted on repaying the loan. Chief Justice Roberts, for a 6-justice majority, rejected both arguments. He notes that repayment of loans leaves the candidate no better off financially than had the loan not been made. Default should not be the presumptive outcome, in other words. But he argues that a candidate with less assurance of repayment will be less likely to loan money to the campaign, thus reducing the supply of speech. Now, at first glance, this might seem like a pretty esoteric case. After all, you might wonder how many candidates can really loan their campaigns over $250,000. Well, the somewhat surprising answer is a lot more than you'd think. In fact, about 90% of campaign debt consists of candidate loans. We hear much these days about the alleged torrent of independent spending in campaigns, that is, spending by super PACs and other citizen organizations that are not part of the candidate's campaign. But in fact, candidate loans to their own campaigns typically total hundreds of millions of dollars and exceed the level of independent spending by a considerable amount. Common sense here tells us that candidates are less willing to make those expenditures when they cannot be paid back, and the data backs that tuition up, both in reductions in candidate loans and the number of candidate loans that are limited to exactly the $250,000 figure that can be repaid back. Note that the limit on repayment will, as intended, and Ted Cruz aside, tend to benefit incumbents who have many fundraising advantages that obviate the need for personal spending in their races. Personal spending is more generally a practice of challengers. And the rule also benefits truly wealthy candidates, such as Michael Bloomberg and Tom Steyer, who can afford to spend money and just let it go, over candidates who, like Senator Cruz, have the wherewithal to advance large sums to their campaigns, but are not so well-to-do that they can simply write off more than $250,000 in debt. So there's not much doubt that the law operated to reduce speech in campaigns and to do so in a way that benefits incumbents. That said, though, as with many Supreme Court decisions, Cruz is probably more interesting for what it says about campaign finance law more generally than for the particular provision the court held was unconstitutional. First, the court reiterated once more that it rejects attempts to restrict campaign speech based on legislative aims other than the prevention of quid pro quo corruption or its appearance, that is, direct exchanges of contributions for votes or other official action. Next, it emphasizes, as it did in McCutcheon 7 years ago, that the claim of corruption or its appearance must be supported by serious record evidence or legislative findings. And what might that evidence consist of? Well, the court doesn't explicitly say what it has to consist of, but it does note some things that are not enough. It specifically rejects the government's effort to support its contentions with a handful of floor statements from legislators supportive of the provision as a substitute for the type of legislative findings that might suggest a special problem. It rejects the idea that a public opinion poll commissioned by the government for this litigation that finds voters think that campaign donors expect political favors is sufficient to show the appearance of corruption. Rejecting this, the court makes an important point. The appearance of corruption doesn't just mean anything someone sitting in a bar or perhaps answering a pollster's question thinks constitutes corruption. It doesn't indicate the general perceptions that people might have. Implicitly, the court reiterates that the appearance of corruption is not a subjective public opinion about Congress, but requires actual behavior indicative of a quid pro quo exchange that simply would be difficult to prove under traditional bribery laws. And the court rejects mere conjecture, noting that while most states have no such prohibition as the law in Cruz, there are not examples of any ensuing corruption in those states. We might also note, although the court did not, that while the dissent argues that the law, quote, for 2 decades has checked crooked exchanges, close quote, in fact, there is no evidence that such crooked exchanges existed before 2002, when candidate debt financing was already common and this law was not on the books. Now, all of this is extremely important because it reflects once again the court's rejection of the approach that was epitomized by David Souter in 2000's case of Nixon v. Shrink Missouri Government PAC, where Justice Souter actually said in oral argument, well, don't most people think that contributions are corruption? And it rejects Justice Kagan's position in defense, which claims that the lack of evidence shouldn't be troubling because common sense tells us that these donors are getting some kind of illicit favor. No, says the court, before you infringe on First Amendment rights, you need actual proof of a real government problem that needs to be solved. Now, the majority also eluded the question of whether campaign contributions are subject to strict scrutiny or lesser closely drawn scrutiny, along a source of controversy within and outside the court, by holding that this law favors either test. But that is significant precisely because it indicates that the closely drawn test used in campaign finance cases here has real teeth. Otherwise, the distinction would have mattered. And in so doing, the court also made clear that its concern in campaign finance cases is not whether a measure is deemed a limit on contributions, thus subject to a lower standard of burden on the government, or a limit on expenditures, subject to a higher burden on the government. What is focused on is the actual effect of the measure on speech, not what is labeled as a contribution or as an expenditure. The dissent, by the way, had tried to apply a more lenient standard to contributions here and argued that this was a contribution limit. It did so with a little bit of sleight of hand, having noted that contributions usually got a more lenient government or a more lenient test. It had referred to the case then as one involving, quote, the use of contributions. But of course, the use of contributions is an expenditure subject to the higher test. In any case, the court makes clear that both tests have some real meaning and some real teeth to them. Finally, the court, as it did in McCutcheon, rejects the idea of a government that can enact, quote, prophylaxis upon prophylaxis. This is crucial because a disturbing trend in the court in the late 1990s and early 2000s had been to accept ever greater encroachment of First Amendment rights in the area of campaign finance speech and public affairs in an effort to plug what were called, quote, loopholes. The idea was that once core political speech could be regulated, that is, direct contributions to candidates to run their campaigns due to corruption or its appearance, then regulation could extend ever outward to get more and more tangential types of speech in order to prevent avoidance of the law. The court has now quite firmly rejected that approach. It had previously done so clearly in McCutcheon and again reiterates that here. In summary, at first glance, there doesn't seem to be a whole lot that is new in Federal Election Commission versus Cruz, but we can say that the Roberts Court, with 3 new members, continues its long, steady rollback of political speech regulation begun with the Wisconsin Right to Life case in 2006. And in so doing so, it further narrows the notion of corruption that might justify such regulation and tightens up the evidentiary burdens facing the government in future cases. This is one of those cases in which essentially the court has said, about our recent campaign finance decisions, Citizens United, Wisconsin Right to Life, McCutcheon versus FEC, well, we really mean it. And that is probably the most important aspect of Federal Election Commission versus Cruz.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.